I apologize if I'm mispronouncing the name, from University of Bologna, with a recorded presentation. Thank you.
To lecture in this extremely important event on the measuring and the metric we have developed and we may want to develop to assess the quality of justice. In the 10 minutes that I have at my disposal, I basically want to first take a sort of a critical stance toward the current metric used to measure the quality of justice, and at the same time to put forth a proposal which I think would be in a way capable to cover and include new developments that we have been observing over the last 2 years in the legal and justice sector. So let me start with what we have been discussing so far at the international level. If we speak of quality of justice, at least in terms of necessary condition for quality, we do refer to the judicial independence. And in this respect, there is nothing new, let's say that way, but this doesn't mean that it is not important. The judicial independence is the conditio sine qua non, so the necessary condition enabling us to refer to aim all the other qualities that we want in the legal and justice sector. So without judicial independence, we cannot do anything else in terms of quality. And I stress this point because lately, and specifically because of the several transformations that have been experienced within liberal democracies, constitutional democracies, but also in hybrid regimes, judicial independence has been put under attack in many ways, more or less explicitly. And in this respect, I think that we need to regain this topic on the top priority of our agenda, in some way, even before we address concerns, matters, objectives, features and dimensions that do relate to the managerial quality of the legal and justice institutions, which doesn't mean that managerial quality is not important, but definitely that it cannot be addressed if judicial independence is not protected. Of course, in terms of judicial independence, if we go into the international debate, we see that it has been in a way operationalized, and we have indicators or proxy that we use in order to see whether or not the judiciary is independent. Of course, the matter of salary that is, related to the status of judges, and in some countries also of prosecutors, the budgeting of the judiciary, especially where we do have a judicial council which is autonomous and is self-governing the judiciary, and in this respect the budgetarian status of the High Judicial Council, it is a matter of concern. I also, as a footnote, recall here the recently adopted recommendation on the new status of the High Judicial Council that has been debated recently in the context of the Council of Europe. Of course, this is, as I said, a necessary condition, but in the international debate, especially over the last 2 decades, we have observed a measured turn, so to say, toward a more managerial understanding of let's say, the quality of justice in the legal and justice institutions. A matter of concern has been the sustainability in terms of input-output ratio. We know this, we know very well this term, and we know that it has been worded in terms of performance, and this relationship between input and output has been measured in terms of resources that are provided to the legal and justice institutions, among which the salary, once again, the budget, of course, the type of staff units, which means also the type of professionalisms that are provided to the legal and justice institutions. And finally, and mostly importantly, over the last 10 years especially, the infrastructures and the endowments of courts. When we speak about infrastructures today, definitely we have in mind the technology and the digital tools that are built and set in order to have courts enabled to operate through the information and technology infrastructures, and with a whole range of tools based on the digital potential, the applied mathematical rationalities, what we call artificial intelligence and predictive justice, which is the output side. And here again, we have no range of indicators, which means that we have developed a matrix, of course, and among the most important and used indicators, we have the disposition time and the clearance rate and the average time frame that are featured by the court systems in treating the proceedings. And of course, this ratio between the number of cases that are treated and the number of litigation issues that enter into the monitor and are uploaded on the agenda of the justice institutions. So in a way, what has become extremely important from the point of view of quality of justice measuring is a focus on governance. Governance in the sense of, on the one hand, the structural conditions under which judges operate, which goes back to the matter of judicial independence, and on the other side, the way resources are allocated, the way resources are managed, and the way this management is subjected to some sort of accountability, both toward the broad public and toward a more experienced, expert, technocratic-oriented audience. Again, recently, despite the fact that we have a no range of indicators to measure the performance and so the efficiency in the way resources are allocated. An extremely important point added on the top of the list of indicators refers to the access to justice. Access to justice is here meant in many ways. Many of them do refer to the fact that the demand of justice coming from society, and especially from vulnerable groups, can be met by means on a differentiated range of tools and mechanisms to settle the dispute. I don't want to enter into the details of this because I wanted to go immediately to my key point here in this short intervention that I have been invited to make. The point is the following one. Of course, we need to balance principles, and to combine different principles within the ideal of quality. And these principles are values. So when we speak about the equality principle and fair trial, both in the sense of a fair trial that is delivered by an independent judge and at the same time in due time, so under conditions of managerial sustainability, due performance and efficiency, we have in mind the fact that we cannot imagine our quality only with reference to the quality as impartiality, but also in terms of efficiency. But we have more in mind. In fact, we have more in mind. When we speak about values, we do have in mind a vision that wants to incorporate this input-output ratio rationale that has been inspiring the overall 2 decades of quality of justice measure, but we want to do more. And I think that here we do need to shift the paradigm of quality of justice from a purely paradigm that has been measured, mostly centered on the ideal of cost, orientation and cost attention, cost-benefit ratio, toward an ideal where the quality of justice relates to the value that we are creating in a society through the justice institutions. And when I'm speaking about justice institutions, I do not have in mind only courts, of course, but we do have in our spectrum also informal justice institutions and the many ways in which citizens do observe justice and the type of expectation they do have toward justice institutions, informal and formal justice institutions. So I think that here we need to have a much more extended, a much broader vision of quality, where the orientation on cost-benefit ratio is incorporated, is covered, is taken into consideration. The ex-ante conditions ensuring judicial independence are extremely important, and they gain the top-ranked priority in this metric that we have to measure the quality of justice. But in the end, we need to add the capacity to create and to spread the value of justice, which means, in fact, that we do promote through the justice institutions, something that I would like to call the culture of lawfulness, which has something to do with, of course, the quality of the judicial function, but goes much farther than this. It is a broader understanding of the quality of justice because it goes as far as reaching the type of values that citizens do associate with the exercise and the performance of the quality of the justice institutions. How to measure this in practical terms? We do have, of course, indicators, and we do have proxy, we do have tools. Social audit is possible in the legal and justice sector. I do have developed myself a set of tools, but also we can rely on prestigious institutions that do operate in the realm of the empirical assessment of institutions, and they can provide inspiring methodologies to measure the values at plural that we create and we strengthen through the justice institutions. We do have also surveys. Surveys they do not tell us the entire story of the values that citizens associate to justice, but they have the capacity to provide an interesting window on citizens' point of view. And finally, I think that an important point is to measure trust. Trust to legal and justice means to settle the dispute. If citizens do not have a high level of trust, the quality of justice may be high in terms of performance, of managerial sustainability, but it is not really a fully fledged high quality, at least not in the sense of the quality that we want. So that's what I wanted to share. I think that at the international level, and here we do have an important role to play, at the international level, we are in the right time, in the right place, after these 2 years of pandemics, to raise a worldwide debate in order to innovate the metric of quality of justice measuring, having 3 dimensions: judicial independence and all conditions ensuring judicial independence. On the one hand, it is one pillar. The quality of justice in terms of managerial sustainability is the second pillar, and it goes directly to the point of the cost-benefit ratio, of course, which is important. And there you put technology, and on the other side, the trust and expectations citizens do have toward justice institutions, both formal and informal, and here we have social audit that is needed. 3 different pillars to measure the quality of justice, and these 3 pillars must be incorporated in a sort of a recursive methodology. I have already had the opportunity to refer to this. I think that we do need definitely this recursive assessment that allows us first measuring and secondly learning from good results, positive stories that we may tell, also in a comparative perspective. Our association can play a big role taking entirely the lesson that we can take from a comparative view in a recursive cycle of assessment that take 3 pillars as said, and in this respect may create a virtuous cycle of institutional learning, which is triggered by a sort of a comprehensive view, a multidimensional view of the quality of justice. Thank you for this opportunity once again, and I'm of course open to meet your questions and to receive your remarks, which are mostly welcome.